Hello guys, let's begin. So in this video I will begin from here. Judicial decisions can be divided into following two parts: ratio decidendi, that is reason of decision. What is the reason or rationale behind taking a particular verdict that the court is delivering? It refers to the binding part of judgment, means whatever the person, this is the rationale that I am giving, these are the provisions or the principles given in the rule books that I am using, and for based upon that I am giving this verdict. So these are the reasons for that decision, and it is the general principle which are either in the rule books or which are set up in the precedents of the courts, and that has to be that is the binding part. I mean, you have to obey that कि ये प्रिंसिपल था, दैट इज़ द स्टेटिक पार्ट कि ये प्रिंसिपल था और इसके बेसिस पे मैंने ये वर्डिक्ट दिया, तो ये प्रिंसिपल तो हर बंदा ही ओबे करेगा ना. जो कॉन्स्टिट्यूशन के प्रिंसिपल केस टू केस चेंज नहीं होते. जज उन प्रिंसिपल्स पे बेस्ड कैसा जजमेंट देता है, दैट कैन चेंज डिपेंडिंग अपॉन पर्सन टू पर्सन. It is considered as general principle which is deduced by courts from facts of a particular case. It becomes generally binding on lower courts in future cases. Obiter dicta is an obiter dictum refers to parts of judicial decisions which are general observations of the judge and do not have any binding authority. Obiter of a higher judiciary is given due consideration by lower courts and has persuasive value. वो higher court can persuade the people of lower courts, it happens obviously, and it is, as we say, the verdict depends upon discretion of court. तो ये जो word है discretion of court, that is basically upon the mindset of the judge who is delivering the verdict. That may not be binding upon people to people, because yeah, everybody has a different point of view, everybody thinks differently. सो दैट्स द केस इज़ वो अपना दिमाग लगा कर ही वर्डिक्ट दे रहा है. ज़रूरी नहीं कि हर बंदा उसी दिमाग से सोचे. अगर उसी दिमाग से हमेशा हर बंदा सोचे तो कभी केसेस ओवरऑल ही ना हो, कभी एक ही केस में दो कोर्ट्स डिफरेंट वर्डिक्ट दे ही ना, क्योंकि मेंटालिटी, थिंकिंग, वे ऑफ थिंकिंग हर बंदे का डिफरेंट होता है, हर बंदे का ब्रेन सेटअप, ब्रेन डेवलपमेंट डिफरेंट होता है. सो एज द जजेस, सो जनरल ऑब्जर्वेशन ऑफ द जज इज हिज डिस्क्रिशन. That is not binding upon anyone else. Having considered various aspects of precedent, that is ratio and obiter, it is clear that system of precedent is based on hierarchy of courts. Therefore, it becomes important to understand hierarchy of courts. Every legal system has its own distinct features. Therefore, doctrine of precedent is applied differently in different countries. In India, doctrine of precedent is based on concept of hierarchy. Modern system of precedent developed in India during British rule, as we learned it in the previous video itself, that precedent system came from the British rule. As I have been telling so many times, that there are also some good things that we have taken from the British people. It was British who introduced a system of courts. By Regulating Act of 1773, a Supreme Court was established at Calcutta, which is now known as Kolkata. So it is very important information that by which year's Regulating Act Supreme Court was established in India, and that Supreme Court was located where, right? So it is an important information, learn it. Later on, other Supreme Courts were established in other provinces. After that, High Courts were established. However, there was no hierarchy at that time. They were independent of each other. Hierarchy could be established only when Judicial Committee of Privy Council became the final appellate tribunal. As we did it, कि वो सुप्रीम अथॉरिटी थी प्रिवी काउंसिल बिफोर इंडिपेंडेंस. आफ्टर इंडिपेंडेंस तो जब हierarchy सेटअप हुई तो सुप्रीम कोर्ट सुप्रीम अथॉरिटी बन गया इंडिया में, लेकिन बिफोर इंडिपेंडेंस जो ब्रिटिश कोर्ट था प्रिवी काउंसिल, वो था फाइनल अथॉरिटी. व्हेन प्रिवी काउंसिल वाज डिसाइडेड टू बी द फाइनल appellate tribunal, at that time hierarchy of courts was finalized for our country. Another milestone was Government of India Act of 1935, which established the Federal Court. Keep underlining Government of India regulating acts के CR में क्या किया. Therefore, as far as hierarchy is concerned, Privy Council was final appellate court, while other courts below it like Federal Court, High Court, Presidency, Mofussil courts were bound to follow the decisions of their Supreme Courts. Lower courts को follow करने ही है Supreme के, जैसे बच्चे बड़ों की बात मानते ही हैं, तो वही चीज़ है, lower courts are bound to follow. Okay. So you can see this flow chart over here. Privy Council, Federal Court, High Court. Federal Court was supposed to be the type of Supreme Court. Presidency, town, as I told you, this is at the country level. So this was by British people. This was at the country level, state level, sub-district level. Post-independence, India adopted its own constitution, which provided for a hierarchical judicial system that is pyramidal in nature. Under Constitution of India, a single monolithic unified command of judiciary has been established. Supreme Court, established by Constitution of India, came into existence on 28th Jan 1950 under Article 124 subclause 1. So you remember by which article Supreme Court came into existence and when. Underline and learn. Such things are important. Even ऐसी चीज़ों की तो dates भी important है. Supreme Court replaced Federal Court established by Government of India Act of 1935. Supreme Court is apex court followed by high courts at state level. Below them are district courts and sessions court. Structure of judiciary in all states is almost similar. That's why we say it's uniform with little variation in nomenclature. नाम different हो सकते हैं, but जो main basic structure है वो same है. Like you can see over here, this flow chart which is given. Okay, now you see. Supreme Court at the country level, apex court of law in India, इसके ऊपर और कोई court नहीं है. High Court at the state level, Sessions Judge and Additional Sessions Judge. This is something at the district level. Then Assistant Sessions Judge, Chief Judicial Magistrate of Class, Special Judicial Magistrate, Chief Metropolitan Magistrate. So this was criminal justice system. You see the heading criminal justice system. Criminal courts का ये है. Criminal courts में sessions judge होते हैं. Then if I talk about civil judicial system, that deals with the family law matters or the civil matters. Criminal courts deal with criminal matters. Civil courts deal with civil matters. So this is the flow chart for civil court. Then this is something about Privy Council. Judicial Committee of Privy Council is one of the highest courts in UK, established by Judicial Committee 1833 to hear appeals formerly heard by King in Council. It is the highest court of appeal for several independent Commonwealth countries, the British Overseas Territories and British Crown Dependencies, जो अभी तक ब्रिटिश के अंडर हैं. Commonwealth countries एक्सेट्रा. Commonwealth भी ब्रिटिश के अंडर ही है, ब्रिटिश क्वीन के अंडर. So इन सब चीज़ों के लिए highest court of appeal, highest court of law is the Privy Council. It is often referred to as Privy Council as in most cases appeals are made to Her Majesty. As I said, Queen के लिए and Queen के अंडर है तो Her Majesty, who then refers case to Judicial Committee for advice. Report of Judicial Committee is always accepted by Queen in Council as judgment. Queen ने आज तक ऐसी किसी भी रिपोर्ट को रिजेक्ट नहीं किया है. सो वहाँ पर Queen की बस एक हाईएस्ट अथॉरिटी है फॉर सिग्नेचर्स एंड ऑल, और कुछ डिसीजंस Queen लेती नहीं है जनरली. इट इज़ जस्ट दैट उनकी भी हिरार्की चली जा रही है. ओके, नॉट गोइंग मच डीपर इनटू दैट. Under the mentioned hierarchy of courts, decisions given by Supreme Court are binding on all courts throughout India, while decisions given by high courts are binding on subordinate courts within that state. Decisions of high courts are not binding beyond their respective jurisdictions. The Supreme Court decisions binding on all courts of India, whether it is a high court of any state or whether it is the district level court of any city of any state of India. And the decision of high courts are binding upon the subordinate courts of that state जिसका high court है. And the decision of high courts on other high courts, it's not binding, but it can be seen as a precedent as well. Decisions of high courts have persuasive value for other high courts of other states and subordinate courts beyond their jurisdiction. It is important to note that Supreme Court is not bound by its previous decisions, with an exception that a smaller bench is bound by the decision of larger bench and that of the co-equal bench. बाइंडिंग नहीं है, बट एज अ प्रेसिडेंट वो उसको ट्रीट कर सकता है, एज एन एग्जाम्पल उसको ट्रीट करके अगर फ्यूचर केस में वैसे ही कुछ सिमिलर सिचुएशंस और मेरिट्स ऑफ द केस का कोई सूट आता है तो उस पर वो वैसा ही वर्डिक्ट डिलीवर कर सकता है. इट कैन टेक इट एज अ प्रेसिडेंट, इट्स नॉट बाइंडिंग ऑल्दो. एंड द एक्सेप्शन टू दिस रूल इज़ कि अगर 2 जजेस की बेंच है तो उसके लिए 4 मतलब मोर देन 2 जजेस की बेंच वाला वर्डिक्ट फॉलो करना बाइंडिंग होगा. Do judges make law? Discussion in foregoing paragraphs regarding hierarchy and binding authority in lower courts raises another important question regarding the role of judges in lawmaking. The Indian Constitution confers power on legislature to make law, while judiciary has power to examine constitutionality of law enacted by legislature. I have been saying this so many times that legislature has the authority to frame laws for the country, but if there is, and all those laws are subject to judicial review by the courts, by the Supreme Court, and if Supreme Court finds out that any law or any legislation which is framed by the legislature as an organ of government is violating the basic principle or is violating any of the provision of constitution, then judiciary has the power to declare that legislation as null and void. The courts also adjudicate upon rights and duties of citizens and further interpret the provisions and other statutes. So provisions of constitution, the sections of IPC, CRPC, all that can be interpreted in its own form by the courts, and they resolve any dispute which arises among 2 parties of India. Through these processes, courts create new rights. I gave you an example also. But this exercise, judiciary makes additions to existing laws of the country. Existing law में कुछ amend कर सकते हैं, कुछ add कर सकते हैं, कुछ subtract कर सकते हैं. It is argued that while doing this, judges actually make law. तो ये law बनाना ही तो हुआ. There are 2 views regarding this. One set of jurists say that judges do not make law, but that they simply declare the existing law. Another set of people say that judges do make law. Obviously, कुछ कह रहे हैं बना रहे हैं, कुछ कह रहे नहीं बना रहे. यही दो views तो हो सकते हैं, हाँ और ना में. So some people say that they are just adding it. They are not actually making the law. They are just adding. They are just amending the existing ones, but they are not making something new. And some say that they are making new. So as I gave you the example of right to internet being a fundamental right, so that happens. Judges make the rights because they were interpreting the existing systems of constitution, and in that they brought up new ones. Jurists like Edward Coke and Matthew Hale are of opinion that judges do not make law. According to them, judicial decisions are not sources of law, but they are simply the proof of what the law is. Judges are not lawgivers, but they discover law. As we say that it is judges only who actually read and interpret that what the constitution makers meant by the statements that they had written in the constitution, what they were trying to say or what they want to be implemented in the country. That all has been read and implemented by the judges of the courts so far, and so they only interpret that what all is given by them. So yes, so according to Edward Coke and Matthew Hale, the judges, they do not give law, they do not are the actual sources of law, but they are only the proof. Whatever decisions they give, that is the proof that what law is, because they give out, they interpret what law is, so they are just approved to implement or to interpret the law. The discover law का मतलब है वही ढूंढते हैं कि उस लॉ के प्रोविजन में एक्चुअली लिखा क्या है, उस स्टेटमेंट को पढ़ के उसे किस तरीके से इंटरप्रेट करना है, समझना है, उसे किस तरीके से अपने सामने जो केस है उसमें इम्प्लीमेंट करना है. That all things is decided by the judge only. They hold the view that judges, while interpreting the law enacted by legislative bodies, contribute to existing body of law. A large part of English law is judge-made law. Above arguments seem to be complementary. It can be inferred that judges do not make law in same manner in which legislative bodies do. Legislative bodies, they discuss it, they debate, and then they come up with law, which was earlier in the form of a bill, as it happens in our country, if I say. And it is complementary in the sense because they are just amending or they are just interpreting what existing provisions are. They generally do not come up with something new from the root beginning. Judges work on a given legal material. As I said, जो भी legislator ने या जो भी constitution makers बना कर गए हैं, उस existing चीज़ पे वो act करते हैं, उस existing चीज़ को वो interpret करते हैं अपने तरीके से और उसमें एक creative role play करते हैं. That is, they give a very significant role in the development of law. That is true, क्योंकि वही लोग हैं जो उन provisions को read करके वो क्या बोलना चाह रहा है, वो provision क्या चीज़ implement करना चाह रहा है, किस चीज़ के लिए है, वो सब वो खुद अपने दिमाग से समझ के. interpret करने का मतलब क्या हुआ, वो अपने आप से उसको समझ के उसको उस present situation case में implement कर रहे हैं. सो इट इज़ अ वेरी सिग्निफिकेंट रोल. अगर लेजिस्लेशन ऐसे ही पड़ा रहा तो उस लॉ को, उस रूल या रेगुलेशन को फ्रेम करने का कोई मतलब नहीं है जब तक कि वो समझा ना जाए कि उसके कहने का मतलब क्या है और जब तक कि उस लॉ को असलियत में इम्प्लीमेंट ना किया जाए किसी केस में. In Indian context, former judges of Supreme Court of India like Justice P.N. Bhagwati, Justice Krishna Iyer enlarged the meaning and scope of various provisions of Indian Constitution through their creative interpretation. तो ये उनके brain development था that led these judges to extend the scope of various provisions, because Justice P.N. Bhagwati, if I talk about, he gave out the provision of PIL, Public Interest Litigation. You can search more about PIL and stuff which was given by these two judges. Supreme Court, too, in its role as through an activist, has created many new rights such as right to privacy, right to live in a pollution-free environment, right to livelihood, and be updated with these rights. Right to education has received considerable impetus during last decade as a result of concerted effort of many groups and agencies towards ensuring that all children in India receive at least minimum education, irrespective of their socio-economic status and their ability to pay for education, in a situation of continuous impoverishment and erosion of basic needs. In a way, right to education is culmination of efforts made possible by judicial interpretations and a constitutional amendment, because right to education act was passed. You read more about this act on your own and you may find out the year or the act by which it was passed. And basically इसमें कोई भी there has to be no discrimination among the children based upon their social status, based upon their economic status, or based upon the ability that whether they will be able to pay the school fees or not, whether they will be able to afford those books, the bags, the stationery items and stuff like that, the uniform, that was not considered. That's why in government schools in India today, all these stuffs are provided for free to the children, just for the sake that they may come to schools and just read, write and learn. For them, the main aim should be to read, write and learn, to get educated, to get the elementary education, and rest everything is provided them for free. Shoes, socks, school bags, books, everything is provided for free. The children just have to come and gain education. But that too is not happening. Food is even provided to them by midday meal. These new rights were created only by way of interpreting Article 21, right to life. Right to life में ये भी include, right to life is a very broad concept, I tell you. बहुत बड़ा एरेना है इसका. These rights developed by courts are in not any sense lesser than laws enacted by legislative bodies. तो ये किसी भी सेंस में कम नहीं होते, ये भी इंटरप्रेट करते हैं, इसलिए उसको वही लेवल में समझा जाता है जैसे कोई लॉ लेजिस्लेचर बना रही हो. It can be concluded that judicial precedents are important sources of law in modern society, and judges do play a significant role in lawmaking. So now, from here, I will continue in the next video.